Good afternoon, everybody. This is Vincent Milletti with Milletti Law. I'm the partner and owner of the firm. In this very short, brief video, I'd like to just touch on a couple of situations that we find happening more and more again. As employers are opening up their buildings, they are implementing vaccination policies. Anyone who knows my law firm knows, we are like vehemently opposed to any kind of regulation that mandates employees or just anyone in general, it mandates employees or just anyone in general that fundamentally believes against a certain practice that encourages, enforces, and mandates it against their will. So I wanted to provide this video just to provide a little bit of guidance. What I'm going to read today comes from one of the many clients, potential clients, and just those looking for some general guidance suggestions. This happens over and over again. So I thought that maybe by providing this video, it would make it a little bit easier to understand, and it'd be easier to digest than just one of my very long blog posts that I basically write like legal briefs, because I am not, anyone who knows me knows, I am not good at brevity. Okay, so let's begin, right? So very common scenario that we have now that companies are opening up, implementing vax policies. We have an employer who mandates a vaccination as a condition of work to return to the office. This particular person has a medical condition which puts her at risk for accepting a vaccination. She apparently notified her employer of a medical condition. The employer pushed back and wants additional information on it. So now she's concerned because even though she does have a legitimate medical reason, it was documented. It was written on a doctor's note that said, hey, listen, she needs an accommodation. The employer, I guess for whatever reason, is suspect. And the employer is asking questions. She just feels frustrated that her integrity, her medical privacy is being kind of like attacked for this very silly reason, especially because my take on this. This vaccine is not prepared. It's not, first of all, it's not a vaccine. It's sort of like gene therapy, okay? It's not validated. It's not tested over time. It's just not ready and too soon and too essentially dangerous. You have maybe 500,000 cases on VAERS where they're reporting adverse reactions, but whatever. Let's go into it. So now here we are. Doc, employer, here's my note. What do you want to do? Employer, I need more info. Let's sit down. So understand what the law is right now currently, right? So right now you're entitled, if you have a medical condition that interferes with your ability to work, okay, interferes with your ability to perform the essential functions as you would function without the accommodation, without that disability, then you're entitled to you are entitled to a reasonable accommodation by the statute. You can look at 20 CFR 1630. That's one of the sections. There's numerous of them. Once that happens and you say you need a reasonable accommodation, your employer is supposed to turn back around and say, okay, well, let's engage in the interactive process. Your employer is supposed to sit down with you, and there are three particular items of reasonable accommodations, like just kind of like three broad general categories that all employers should consider when going through the interactive process. The first category are those accommodations which you, the employee, desire are reasonable in order for you to perform normally. Those that are customarily performed, so you may perform essential functions. So for instance, like a cashier, maybe a chair so the cashier could sit. That's customarily performed for the cashier. The third category is those that enable you, the employee, to participate equally with others who do not have the similar disabilities as yourself. I mean, these run down the gamut. There are thousands of cases, thousands of situations. This includes such accommodations include often, making existing facilities accessible, maybe job restructuring, placing you in another position, part-time modified work schedules, maybe acquiring or modifying certain equipment, changing tests, training materials, other policies, providing qualified interpreters. Let's say your speech is impaired for whatever reason, or your reading is impaired for whatever reason, getting qualified interpreters or qualified readers. Perhaps your company vacated a position and now you would do well in this position, so they would reassign a vacant position. So there are a whole slew of things to do. It's even written in the statute. I mean, that same section I cited to 29 CFR 1630, really goes down for alphabet A to Z, and then AA, ZZ, BB, it's all over, right? Lots. So, big idea. You have an entitlement, as an employee, you will have a right to a reasonable accommodation so long as that accommodation does not cause an undue hardship on your employer. An undue hardship generally is something to the effect of like it costs a substantial amount of money for an employer to make the change, or the employee is really disadvantaged. So, for instance, the quintessential example that has been in existence before COVID was an employee wanting the job held open indefinitely. So an employee goes on sick leave, has a chronic injury that's long-term, chronic illness, asks the employee to hold the job open for me. Holding that job for you for an undetermined amount of time, an indeterminable amount of time, is a hardship, right? So that's like kind of like a quintessential one. So just keep that in mind. So you're entitled to reasonable accommodation, but not if it unduly burdens your employer. Okay, so now we go into like proving this disability, right? So in our situation, remember, she handed the doctor's note, hey, listen, here's the doctor's note, I'm disabled, you got to give me accommodation. So this particular employer wants to inquire about that and wants to ask more questions, okay? So that's already a gray area right there, because that's different, because that is, you have to, it's very, 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 the employer has to be very careful to not ask what's known as disability related questions that are unrelated to the job, right? So this employer that gets this vaccine note, right? This vaccine doctor's note, can't call the doctor and say, hey, listen, what medical condition does she have that she can't get a vaccine? Because that's not a job related question, right? So that's just it. What if she suffers from, I don't know, I forgot the word where you bleed profusely. I probably should do more prep for this stuff. But let's say she bleeds profusely from pricking skin. I mean, you prick that, you take your vaccination, you take your gene therapy, she bleeds to death and dies. Big problem, right? So that's just like an example. I mean, there are thousands of them. I just am not prepared for this because I just want to make this video because I figured the video would be more helpful for everybody than just me putting a bunch of words on paper. So your employer's not supposed to inquire so deep into that. It's got to be job related, right? There are statutory situations where the employer may not ask you questions. And those two situations are, one, when the disability and the need for accommodation is obvious. For example, January 1st, you could walk to work, and you could perform your job as a cashier, standing. January 17th, you get hit by a car and your legs are broken, and you need a seat. You need to have a wheelchair. Accommodation is obvious, right? Legs are no good, whatever. The second situation is you've already provided the employer with sufficient information to substantiate that you have an ADA disability and that you need a reasonable accommodation. This is kind of like the doctor's note. We'll get into that. So this is why it gets very sticky at this point. So the ADA has, depending on where you are in employment, by the time you get that question, it has certain categories, right? So it could be pre-employment, prior to an offer, post-offer, and after employment begins, right? So I don't want to go into all those other ones because this is very limited to the person that's currently working. So let's go to after employment begins, right? So if that question comes up at a point after the employment begins, then the employee needs to be very careful that the disability-related inquiry is actually related to the job and is consistent with the business necessity. So the terminology that the statute uses is generally that, and I'm paraphrasing it here, but it's generally that, an employee may only seek information about an employee's medical condition when it is job related and consistent with business necessity, okay? So it's got to be two purposes. It's got to be related to the job. It's got to be consistent with the business necessity, okay? This means that the employer must have a reasonable belief based on objective evidence. That means the documentation, objective, not manipulated, not opinionated, but objective documented evidence that A, the employee will be unable to perform the essential functions of the job because of that medical condition, or the employee will pose a direct threat because of that medical condition. So if the employer, so let's use, I use the vaccine for an example, right? So let's say here, if the employer believes that you are a direct threat by that not having a vaccination, by not having, the gene therapy, they may be able to push back on that. That's really the questions that are in the courtroom now. Historically, flu vaccines are not that type. Where right now you're getting through COVID, the first round, you're having this Delta variant. People, even with vaccinations, are still getting this Delta variant. So, I mean, from my perspective, this is the exact same as a flu variant, but the reality is the media doesn't see it that way. So the media's got to terrify everybody. You know, you could think, when you think COVID, think Jerry Lewis telethon. No cases, no cases. Can we get the cases on the board? Bing, bing, bing. Right? So point is though, that's where we are. So back to back to it, right? So let's say they believe you're a direct threat. They can't ask you questions, but they believe you're a direct threat, right? So what may they ask, right? So they may just kind of like substantiate it. You know, I didn't notice this last week. How come you didn't disclose this last week? I didn't notice, you know, you don't have any physical ailments. Can you just kind of give me like, is there another accommodation, whatever the case is? They have to be careful. They can't pry too deep. They can't say, well, they can't ask you if you're taking medication. They can't ask you about your prior work history. They can't ask you about all these kind of things. What they really should be doing, the employer at this time, if that's really the case, what they really should be doing is sending you for a second opinion. They are entitled to send you to a second opinion, a doctor of their choice, because this is something that typically happens in all reasonable accommodation settings. Is what happens is, you know, I represent, just so you know, I represent employers, okay? I don't represent employees. I represent employers. I think this whole COVID thing is silly, so I always recommend against these kind of things to my employer. I always recommend my clients, you can go ahead and say we encourage it. You can go ahead and say we would like you to have it. You can't go ahead and say you must have it, otherwise we're going to adversely affect you. Because quite frankly, at this point, it's so difficult to get people back into the office, especially when they've been enjoying their work from home so much, that I would like, there's nothing I want in my life to burden that, you know, employer anymore, right? So basically they are permitted to ask you to go get a doctor for a second opinion. That's permissible, but as far as disability-related questions concerned, they got to be very careful. In that situation, if I was the employee, if I were you that got that, the employer that inquires and says, hey, I need more proof, I would say, you know what? Put those questions in writing, send them to me in writing. I will review them with my lawyer, and I'll see if you're entitled to that. The reason why you put that in writing, everything's in writing, because also, you cannot, the EEOC, the Equal Employment Opportunity Commission, has said you cannot be adversely impacted simply because of your objection to whatever, taking a vaccine without an accommodation. You could be, they can make it as a condition of employment, but the EEOC has flip-flopped. They're not taking a position. Plaintiff attorneys, defense attorneys, all of yous, that you send your stupid emails out to people and you send your stupid spam and you tell everybody about this stuff. That's not right. You're going to get your clients sued, I promise you. And your clients can be very upset. So I'm going to be very clear. And you could call me, vmaletti at malettilaw.com. I will more than happy. I will show you exactly what you're talking about. I deal with this every single day. I've been involved, not just COVID, but I've been involved overall in about 1,200 cases with employers on a variety of levels. And I'm telling you right now, every single one of you out there that says to your employer, you could be firm on this, and in all situations, you're getting your client sued. And you're making your client very upset, and their premium on their EPL insurance is going to be very high in the future. So that's basically just real quick. That's in a nutshell, right? So just keep in mind. So I'm going to leave it off with, one offer for you. If you're still interested, I do offer a free flow chart. Go to my website, download it, email me for the password, send me an email for the passwords. You know, if you sign up to the newsletter, whatever the case is, let me know you signed up to the newsletter, show it to me, email me for the password, you can get it. And that's realistically, that's where we're going to go. You got the flow chart. The flow chart's going to show, you know, step one, what the employer says, employer, employee, employer, employee. And then what happens at that point, we're going to collect your emails. When we get your emails, we'll just send you a password. You open it up. More than happy to help you. If you have any questions, concerns, ask. Big nutshell. If they inquire, get it in writing. It protects you from retaliation claim. It protects your interests. It protects your rights. It protects your medical privacy. You do not need to be concerned. You do not need to. I understand the business aspect of it. I understand the scare. I understand what happened. I understand everything as a concern. You know, people concerned with it. LD employees. I'm encouraging all business owners. I'm encouraging you. If you are going to mandate it, then happily give out exemptions. Freely give out exemptions without challenge, because you are going into uncharted territory. First of all, the law is very dry. There's a specific case with a supermarket called Giant right now that's going up there. So the Giant was just aggressively determined to show that, you know, COVID is a immediate life-threatening harm. It is not. It has a survival rate of 99.97, and that's in the older people. Not even with people with comorbidities, with 2 or 3 comorbidities, not normal people, okay? And the vaccine has probably killed more. The vaccine, according to theirs, is up to 6,000 deaths, over 6,000 deaths, okay? So I just like, make a smart decision. Don't be Giant. Giant's in litigation for years, and they're going to be in litigation for years because that's a class action lawsuit. Fortunately for Giant, the plaintiff in that was a little stupid. The plaintiff in that was nasty, rude. He was one of those macho guys that didn't want to. It was one of those like macho guys that no one's going to tell me what to do. No, we don't do that. So, all right. Final point. To answer your question, everything in writing. Get it in writing. Retain your attorney. Pay your retainer. Whatever it is. Attorneys don't work for free, expect that, but you're paying for not only the integrity of your medical rights, but the integrity of the system as a whole, okay? I will give you the flow chart if you like. Email me the flow chart, it'll be on my website. It's gonna be on the policy section. It's gonna be accessed, it's gonna be accessible only by way of password. Sign up to my newsletter, sign up to my newsletter, and I'll drop the password. Keep it handy on you, and, you know, do the right thing. Have a beautiful day. Yours in love, lifts, and everything law. Vinny Miletti, Miletti Law. Thank you for your time.